probably clicked on this video because you have the next best Facebook or Google idea, but you don't really know where to begin, or you want to make sure that you're taking the right steps moving forward to ensure that your business is going to be successful. In this video, I'm going to go over all of the important decisions you need to make when starting your own business or starting a tech startup. This video is not intended to replace legal advice. If you're serious about taking your business to the next level, please consult with an attorney to make sure you're protected for the future. When I say decisions to be made about your business, there's really 5 decisions that I'm talking about. Your business form, how you're going to divide equity, the way you're going to govern your new corporation, your business plan or capitalization plan, and the state of incorporation and registered agent decisions. Most businesses elect either one of the 2 forms. The first one is the LLC, the Limited Liability Corporation, and the second one is the corporation. The benefit of an LLC is that it's a lot simpler. It's governed by the members or owners of the LLC. The taxes are passed through, so you only get taxed once rather than twice with the corporate form. The downside of an LLC is that the individual members can be liable for torts and, say, if they personally guaranteed some of the loans of the LLC. A corporation is a great way to safeguard your company for the future. While the corporate governance is a little bit more complicated with shareholders, board members, and officers, it's actually a lot easier to have people invest in a corporation than an LLC, because a corporation is a little bit more of a safer investment. Your taxes on any profit coming into the corporation get taxed as they come into the corporation, and then again as they are paid out to owners of that corporation, but you will enjoy no liability for any dealings with third parties whatsoever. The only liability you'll essentially have is to the shareholders. This is because the corporation steps in for any actions of the corporation. So if Coke were to put a finger in a Coke bottle, it would be the company Coca-Cola that is responsible for the damages resulting thereof, not the owners and not the officers of that corporation. One of the hardest decisions you'll face in your new company is how to divide equity between shareholders or members. Equity is the ownership interest of your business. So for instance, if you and your brother were to go into business together, who owns more of that business? Who's putting in more work and who's putting in more capital? These are important questions to get out of the way at the very beginning. The majority of business disputes that I see are between partners or shareholders who disagree after the fact about who owns how much of the company. That's why I highly recommend you hire an attorney to iron out these details before they become big problems down the road. Equity disputes have a high potential to ruin your business before it ever gets off the ground. I always advise my clients of what I call the Silicon Valley Rule. The Silicon Valley Rule is essentially that capital is worth 4 times that of labor. So if you have a partner who's just putting in labor and a partner who's putting in capital, the partner that's putting in capital, his share should be 4 times as large as the person just putting in labor. Now that depends on the amount of capital and the type of labor, but it's a good starting point when negotiating equity. When negotiating equity, a big hurdle for most people is that idea of the payday. You should never think about the payday when negotiating equity. You should think about control. How do you see this company being controlled in the future? Now, having a focus on control rather than the payday usually leaves companies in good hands in the future. When making decisions about corporate governance, what you're really making a decision about is how your business will function. If you're a corporation, then your shareholders will elect a board of directors, and those board of directors will appoint officers. But how many shareholders are needed to appoint a board of directors? And how many board of directors are needed to appoint an officer? These are the kinds of decisions that you need to start thinking about. A quorum is the amount of people necessary to make a decision. So a shareholder quorum might be 50 to 60%, where a board of directors quorum on certain issues should be 100% of the board of directors. For instance, if your company wants to pivot from selling health products to selling health insurance, that's a big decision, and you want all of your board of directors on the same page about that decision. Another important sticking point is how do you want to discipline someone who is acting badly within the company? If a board of directors opens up another company that directly competes with yours, hey, you need to do something about that. This is something you need to decide now, because if it's left vague in the future, then that person is just going to stay on your board of directors and steal your clients. You may think it's too early to start making decisions about your business plan and capitalization, but it is never too early. I've seen businesses that struggle to get capitalized right out of the gate, and I've also seen companies where venture capitalists have gobbled them up before they can even make a product. It is important now to decide how you want to be capitalized, because your governing documents need to reflect that. For instance, if your goal is to have angel investors capitalize your company, then you want to reserve a little bit of equity for those angel investors. Whereas if it's your goal to get that $2 million check from a venture capitalist, you need to make sure that you stay in control after you get that $2 million check. Also, if it's your goal to start selling products and services right out of the gate, you need a plan for how you're going to save that money for taxes later on. Trust me, the penalties for not paying your taxes as a business can really destroy your business. The last decision you need to make is, where is your company going to call home? Usually, this depends on the type of business you're doing. So if you have a storefront, you should probably incorporate in the state where your storefront operates. Most tech startups, which don't have a home office and operate around the globe, choose to incorporate in Delaware because their state tax law is pretty friendly. So how do you incorporate in Delaware if you don't know anyone in Delaware? This is where the concept of a registered agent comes in. A registered agent is either an officer or an attorney who receives documents on behalf of your business. These documents can be anything from official documents from that state to civil lawsuits filed against your company. That's why it's important to have a registered agent that you trust to deliver those documents to you. There are many registered agent offices all across the United States who will do registered agent services for you for $25 or $50. Some attorneys will also offer extra services, such as consulting with you on every filing that has been delivered to them. I hope this video has got you thinking about the decisions you need to make when starting your business. Again, this video is not legal advice. I recommend, if you are serious about starting your business, consult with an attorney. In our next video, we're going to talk about drafting the initial filings, registering your company with your state, and drafting the initial shareholder agreements or membership agreements. These are very, very important for the future of your business. I'm Mario Latona, and you've been watching The Law Mogul. See you next time.